This is a very important subject that many employers seem to have missed in last year's budget. Basically, New York State in 2018 supported a whole bunch of new protections for victims of domestic violence. It really changed how we look at this. There is somebody not on mute. If you could take a look, and if you could mute, please, that'd be great. And you know, you really are going to have to put in place a reasonable accommodation policy for victims of domestic violence. Is the result of this. New York State is not saying that per se. However, if you read between the lines in what is here, you will see that the only way to properly deal with this situation is an employment policy telling employees this is what we expect of you. The law here is very pro-employee in that you may actually wind up firing someone for a no-call, no-show. You subsequently find out that they were a victim of a domestic violence. They give you notice of that after you have terminated them. You're going to have to hire them back or undo the termination. So there is a lot here, extremely important. It's not a ton of substance, meaning, you know, it's probably 45 minutes of material, if that. But the concept is simple. In addition to religious accommodations and in addition to disability-based accommodations, New York employers now must reasonably accommodate victims of domestic violence. So I put up here all my contact info in case you have a follow-up question. I'm also on social media, Twitter and LinkedIn. I post stuff very regularly there. Easy, simple way to follow updates, especially with COVID-19. My office seems to be putting out a legal alert every day on the subject. Okay, so let's talk a little bit about this new law. It became effective November 18th, 2019. So it's been, we've had about 6-7 months here where it has been in place. Probably COVID-19 has overshadowed a lot of the straightforward labor and employment issues that employers are now faced with here in New York. And one of the other ones we'll do on a future webinar, we've already done the COVID-19 sick leave. We're going to be doing in the future the new New York State has put into effect a new sick leave law that applies generally. It's modeled after the New York City law. That will be another webinar, which will be upcoming. We have a few months before that will go into effect, so we'll probably push it off to some point in the summer. So a victim of domestic violence in New York has been a protected classification for years. It is nothing new in that regard. The rationale behind it was rather simple, because this is what was happening. The victim of domestic violence would be at work. The disgruntled spouse, boyfriend, whatever the case may be, girlfriend, comes in and causes a scene at work. Many employers would terminate the employee because of the drama being caused in that regard. That is the simplistic view as to why domestic violence victims are protected in New York. So the general rule is here. It's going to be an unlawful discriminatory practice for an employer because of the individual's status as a victim of domestic violence to refuse to hire or employ or to discharge from employment such individual or otherwise discriminate against them in terms and conditions of employment. And some of you may say, well, how would we know during like the hiring process in that regard? I kid you not. A few months ago, I was reviewing an employment application, and the employment application went into, are you a victim of domestic violence? Do you have protective orders against individuals? Have you filed police reports against your spouse or significant other or someone else? And I read it, and I was in utter shock that an employer would want this information. and it was a rather sophisticated employer. We finally convinced them, given with the slides that we're going over here today. It's like, no, you can't do this, and here's why. So another protection that is embedded in the law, it's basically going to be illegal for you as an employer to print something, be it a statement, advertisement, publication, or whatever it is. Don't get fancy by trying to cause it. Or to use any form of application for employment, or to make any inquiry of a prospective employee. That would be during the job interview. Yeah, we didn't put it in writing, we just asked it. Yeah, it doesn't matter. Whether you put it in writing or do it verbally, it makes no difference. Which expresses directly or indirectly any limitation, specification, or discrimination as to the status as a victim of domestic violence. It's a fancy way of saying don't ask if they are a victim of domestic violence. You have all interviewed employees that have, or applicants that have, what I refer to as diarrhea of the mouth. They tell you everything about them, their medical conditions, their marriage situation, their sexual orientation. The rule of thumb is simple in that regard. If you're a note taker, don't take notes on anything that is a protected class. And you have one of two options. Number one, let the applicant talk, file it away for future use, or stop them in saying, I didn't ask you that, and that information will have no bearing on whether we hire you or not. I'm a fan of the second, stop them. One of the things I want you to realize is that there are testers out there. Testers are individuals who portray themselves as a job applicant, but they're really working for could be a third party, could be the state of New York, it could be a state of New York employee. They're testing you to see whether you're going to make illegal job inquiries of the applicant, and they're probably wired for sound. So it doesn't matter what you call it, doesn't matter what form it is in, doesn't matter if it's verbal or written. You cannot inquire whether the applicant is a victim of domestic violence. Okay. I am a good-hearted employer. I am generally concerned about my employees. And I notice Jane is arriving late for work. She is bruised. She's not herself. Can I extend the olive branch? Absolutely. As an employer, you are always allowed to provide assistance, initiate the reasonable accommodation process for a victim of domestic violence. As long as you're doing so in good faith, you're not trying to find this information out to do some backdoor termination on the person for some other reason. There's also going to be a group of you that won't do this, meaning I'd rather just focus on the conduct, what the employee is doing wrong, build the file and terminate, even if the person is a victim of domestic violence. That is acceptable, that is allowed. You don't have to initiate the process per se. I think the better practice is to provide assistance in that regard to the employee. And we'll give you some examples of what reasonable accommodations are in a minute. So I started out by saying you must now grant reasonable accommodations to an employee who is known by the employer to be a victim of domestic violence. If you don't ask them, you might not ever find it out. So it's a question of knowledge. Once you know, you're stuck in the reasonable accommodation process. So pick your poison in that regard, and you're going to have to live with it. But you do have to do this. The law does not require that it be a written policy, a written reasonable accommodation policy. I think it's clearly a best practice that religious, disability, and now domestic violence accommodations, that there be a policy accommodating it, or a policy setting forth in the employee. If you need this, this is what we will give you, and this is how you initiate it. This is how you tell us about it at the end of the day. Reasonable accommodations are going to be limited to those accommodations when the employee must be absent from work for a reasonable time. And we'll sort of get, New York State gives us some very general rules on what factors we can consider. What is reasonable will depend on the workplace. So a smaller establishment that has 3 or 4 employees versus a larger establishment that has 3,000 employees. The rules are going to be totally different. What is not different is you don't have to grant the reasonable accommodation if it causes an undue hardship. And we will explain to you a little bit about what the undue hardship rules are in that regard. Okay. Again, restating it, you have to grant the victim, a known victim of domestic violence, who must be absent from work for a reasonable time, a reasonable accommodation. However, it's not for every circumstance. It's going to be limited to the following areas that you as an employer. That's why if you want to have a written policy, you regurgitate these 5 areas in that policy so that the employee knows about it. Some of you may think, I don't want to do that. I'd rather wait and see since I don't have to have a mandatory policy. Let's see if these circumstances come up. I don't want to educate my workforce too much. They might try to abuse this. I disagree. It is true that the abuse is always present. However, they're going to have to come up with some documentation in order to substantiate this. They just can't say, oh, I had to go to court. If they went to court, there's a document. I had to file a police report. There's going to be a police report. I had to go to the emergency room because my boyfriend assaulted me. There's going to be a discharge record. So there will be ways to confirm the story at the end of the day. So what are these situations? I already alluded to this first one. The individual is seeking medical attention for him or herself. And let me stop there, for him or herself. Don't assume the victim is going to be a female. It can very easily be a male. I've seen that many, many times. The reaction that males get is sort of like a reaction that a male gets when they say, I've been sexually harassed. Sometimes it's like, seriously? Yeah, seriously. So make sure when you train your supervisors on this, in case they get the inquiry, that they don't chuckle at the male. They don't say anything stupid to the male, because it can be a male or female. So the first circumstance, the victim of domestic violence is seeking medical attention for themselves or a child who is a victim of domestic violence. Now, they put an exception in here, unless it was your employee that caused the kid to be hurt. So if they're the perpetrator of the domestic violence on their own child, you do not have to grant a reasonable accommodation for that. Number 2, obtaining the employee has to obtain services from a domestic violence shelter program or some type of rape crisis center as a result of the domestic violence. The employee has to obtain counseling related to an incident or incidents of domestic violence that would include their own children, unless the child, the perpetrator, is your employee at the end of the day. And one of the, just as an aside, if your employee has an order of protection, I might put in my policy, hey, if you have an order of protection against someone, please share it with us so we can take appropriate steps in the workplace in that regard. What would some of those steps be? If a phone call comes into reception from the person, we know what to do with it. If the person shows up at reception, we know what to do with the person. Maybe we block that person's email to our company system across the board. There are many things that you can do. I'm a fan of getting the protective orders, seeing what you can do. One of the things you will have issues with is what if the employee is dating another employee and gets a protective order against that other employee. Yeah, that happens from time to time. It could result in someone being terminated, not the person who got the order, I can assure you, but maybe the other person, or the person is placed in an unpaid leave status for some period of time. So though that is a potential issue, that can come up as well. For participating in some type of safety planning and taking other actions to increase safety from future incidents of domestic violence. It could include a temporary or permanent relocation in that regard. And you're like, well, wait a minute, they relocate. Does that mean they're not coming to work? Yeah, it might mean they're not coming to work for some period of time. How long we have to allow them to be out of work is decided on a case-by-case basis, as are all other reasonable accommodation circumstances. So just keep this in mind. We really have to evaluate it. We have to evaluate it quickly to determine what we're going to do. We have to have some frank discussions with the employee. Yes, I'm being relocated temporarily from Elmira to Watertown. They can't work for you. The reasonable accommodation you might grant for a week or 10 days, maybe even 2 weeks, and then that's going to be it. I mean, they're going to have to come back to work at some point. So don't think it's a forever thing. It's not. You just have to evaluate it on a case-by-case basis. Do not try to come up with a broad set of rules that apply across the board, because the requirement is an individualized analysis. The last one is they are obtaining legal services. They're dealing with the county attorney or the local DA to help with the prosecution against the perpetrator. They have to go to court in relation to the incident of domestic violence. Again, there will be court papers, potential order of protection, etc. So those are the 5 areas that you would have to grant the reasonable accommodation in. That's it. It doesn't go beyond that. If the request for a reasonable accommodation falls outside one of those 5 areas, it falls outside one of those 5 areas. You would tell the employee, the request is denied. Here's why. Could I, because I'm a nice employer, grant a reasonable accommodation for a victim of domestic violence that goes beyond these 5 areas? Sure, that's up to you as an employer. I don't care. Just remember, other employees may find out about it, and the next victim of domestic violence that comes across may want the same thing. I don't believe in the concept of a precedent. I think everything is individualized on a case-by-case basis, but the word gets out. Just recognize that. So, Mike, you've said I have to grant the reasonable accommodation in one of these 5 areas unless it causes an undue hardship. The undue hardship concept is the same as it exists for religious accommodations. It is the same as it exists for disability accommodations. That is the exception to the rule. Now, this slide, make sure you understand it. Unless the employer can demonstrate that the employee's absence causes an undue hardship. What does that mean? That is a shift of a burden of proof. It is not up to the employee to show it would not cause an undue hardship. It is up to the employer to show it would cause an undue hardship. So that becomes very, very important at the end of the day. Please realize it's your burden of proof. You have to have your act together. You have to be able to prove the undue hardship. Mike, what factors do I, as an employer, have to consider in the undue hardship arena for a victim of domestic violence? New York State has given us a series of factors. As you're about to see, they're very broad in that regard, and you sort of have to adapt it based on the specifics of what the employee is doing for you and considering the specifics of your business. So one of the important factors that the state stresses is the overall size of the business. How many employees are there, the number and type of facilities, and the size of the budget. And what this gets to is the following. The larger you are, you probably have to grant more things. Let me be frank. That is what this is. And you're going to have to suck it up and grant the reasonable accommodation, whether you wish to or not. The larger you are, the more you can bear, the less undue hardship, I guess it is, that you have. The second consideration is the type of business operation in which the business program or enterprise is engaged, including the composition and structure of the workforce. We would look at, what does the business do? What is the relative importance of that to the business? And can we, in essence, get away with not having this victim of domestic violence here for some period of time without it really hurting the operations in that regard? Can we have someone cover for the employee on a temporary basis? If it's a large organization, the odds of that being able to happen are fairly easy. If it's a smaller organization, it may be more difficult to have someone fill in because there may not be anyone to fill in. Does my employee requesting a reasonable accommodation as a victim of domestic violence have to give me notice? Yes. Does it have to be in advance? No, it does not. So this slide sort of says what the general rule is. The employee who has to be absent from work is to give the employer reasonable advance notice of the employee's absence. Your employment policy would become very important here. Who would that notice go to? You just don't want it going to anyone. And, we ran into a problem recently with another one of our clients. They notice was given to the supervisor, but the supervisor did not give notice to HR. HR knew nothing about the reasonable accommodation request, and they should have. So when you train your employees, make sure you realize they need to know what to do with it once they get notice. So the general rule is you got to give us notice. Your policy would control who gets that notice in the form of the notice. Big exception, unless such notice is not feasible. So here's the example. Employee is assaulted by their boyfriend the evening before. They're in the hospital. They're unable to give notice to you as the employer. Maybe they're unconscious and recovering, and they're in the hospital 3 days. Then they get out of the hospital and they give you notice. But you've already terminated them. You have a no call, no show, 3-day rule. You have to hire them back. All right, so let me be frank in that regard. This advance notice not being feasible really requires that you hire them back at the end of the day. So realize you may have that obligation if you get notice after the fact. Once they get out of the hospital, they're in a coma. What time period do they have to tell us? It is a reasonable time period after the absence, and you as an employer can request a certification and that the employee give you to certify why were you out. And you're going to see in a second what some examples of that is. So you don't have to take them at their word. You can get documentation in that regard. What if the employee can't provide the documentation, or what if the employee refuses to provide the documentation? If they refuse to provide the documentation, the termination is going to stand. If they can't provide the documentation, I would at least have a discussion. Why not? Don't you have a copy of the discharge papers? What is the proof that you have that you were in the hospital? You can call them out on that, and there's no problem. You're not allowed to take them at their word. Don't assume your employees are as organized as you. Don't assume that they understand what you're asking for. You may have to walk them through it nice and slow. So what is this certification? Give me some examples, Mike, of what will qualify. So number one is a police report indicating that the employee or their child was a victim of domestic violence. Look at the date of the incident. If it was 6 months before, it's not going to count. It has to be match up with the dates of when they were out. Police reports are not always available immediately. The employee may be being straight with you. They may need a few days to get it in that regard. A court order of protection or separating the employee or his or her child from the perpetrator of domestic violence. That's why I said I'm a fan of getting the orders of protection. I would just tell the employee, hey, you get an order of protection, we're here to help. Tell us about it in that regard. And again, some of you may be of the philosophy, no, I'm not going to do that, because once I do that, I know they're a victim. That's up to you. Other evidence from the court or the prosecuting attorney that the employee appeared in court. The local DA hands the person their business card, writes a note on the back. Employee was with me doing X, Y, and Z from this day and this time. Questions, please call. You're free to call. I'd go ahead and call, document your call, and that's your documentation. So be a little flexible in that regard, because some of it can be very informal. And lastly, documentation from a medical professional, domestic violence advocate, healthcare provider, or counselor that the employee or their child was undergoing counseling or treatment for physical or mental injuries or abuse because of domestic violence. The scribble pad, we all have seen the one-page doctor notes that sometimes don't make any sense. Can I call and get clarification if it is not clear? I'm of the belief you can in this area. Mike, can I take the employee at their word? Yes, you can. That is up to you. The same goes with religious and disability-based accommodations. You can always take the employee at their word in that regard. There will be potential overlap between disability and domestic violence because the employee may suddenly be diagnosed with post-traumatic stress disorder as a result of domestic violence, and you're going to have to engage in the reasonable accommodation efforts on two fronts, disability and domestic violence. So remember, the overlap is possible. Please remember employer confidentiality. It's the same rule, I like to say, as it is for medical and religious. Supervisors with a need to know. We keep all the domestic violence information. Maybe you get a copy of the order of protection, maybe you get a copy of a medical note, maybe you get that little card from the DA. Put it in the employee's confidential file, which could include the medical records. I'm fine with that. But you must maintain confidentiality. You're not free to discuss it openly with staff. You are not free to discuss it openly with supervisors who do not have a need to know. There is an employer confidentiality rule. You must follow this, no ifs, ands, or buts about it. Please keep that in mind. Some of you give your employees leave banks, vacation, sick, PTO, personal, whatever it is. Mike, you sound like that's a surprise. Some employers don't. You're not required to. You just have to tell your employees in New York what your leave policy, leave banks are. Most employers do. So an employer may require that an employee charge any time off that they took because of these reasonable accommodations against their leave bank where available. Now, if you have the pleasure of having a union, this may be addressed in the collective bargaining agreement. Just follow the CBA. If you already have a policy in this regard in your handbook, follow your handbook and policy. To the extent you need to update it, please do so. Any absence that cannot be charged against the leave bank because maybe the employee has no leave, it's leave without pay in that regard. So please keep that in mind. Lastly, health insurance continuation. The employee who must be absent from work will be entitled to the continuation of health insurance provided by the employee to which the employee is otherwise entitled during any such absence. So we have to evaluate how long the leave will be for. We have to evaluate the impact of the leave on benefits. And then if health insurance is involved, then you're going to grant a 1 month leave of absence without pay as a temp because the employee is temporarily relocating to Watertown for that month. Make sure you continue the health insurance in that regard. And in sum and substance, that's it. That is your rules under that. Before, again, if you have questions, you may want to type them into the chat box. I see one already. My closing thoughts are as follows. Put this in writing. Make sure you train your supervisors on what to do, including the confidentiality requirements. And please realize one of the biggest things here will be for you to understand the concept. They're entitled to it unless you prove the undue hardship, and you may have to undo a termination because the employee was in the hospital or something like that. You might not know in that regard. The law is in effect immediately, so I think the quicker you turn to revising your policy or adding a policy and training your supervisors in that regard, the better off you will be. And knowing that we're just starting to get back to work in this state, you can do it remotely, face-to-face, or in writing in that regard. So I will, if you have questions, let's ask them. Let me see what's in the chat box. Yeah, the first one has already been answered by the chamber. I will hang here for a minute in case anyone does have a question. But you're probably saying this isn't too complicated. It's not. So approach it from that perspective, but most employers are ignoring this. They simply don't know that this requirement is out there now. I think the written policy is the way to go, distributing it to your employees in that regard. Okay, I see no additional questions. Unless, if you think of one afterwards, you're free to email me. I'll get back to you as soon as I can. I know we're in the process of setting up other webinars as we go throughout the summer. This is probably going to be our new normal for a bit, and hope maybe eventually we get back to seeing each other in person. Who knows? So thank you, everyone. Enjoy the rest of the day, and if you do have something else that you think of later on, feel free to email me. One question I thought of my own is, does the state have some type of policy? They do not. I think there's no example policy that the state has distributed in that regard. I think you can take my slides and generate a policy in that regard. So again, no questions. So thank you all. Have a wonderful day and week, and look forward to talking to you again in the near future. Take care.
Thank you so much, Michael, and thank you everyone for joining us.
Take care, everyone.